Hello and good afternoon, good morning or good evening, depending on where you are from Hamburg. My name is Olaf Hartenstein and I have the great pleasure and honor to welcome you to this webinar on behalf of the organizing committee. These are my colleagues and friends, Simona Matta from Paris, Paolo Lombardi from Torino, Alberto Passino from Trieste, and of course the UIA team, particularly Colette Surin. It is already a while ago that Alberto Passino had a splendid idea. He's from Trieste and he announced to us that in July 2020, the Euroscience Open Forum, the ESOF, would take place in his beautiful city, and that this might be an occasion to bring together highly eminent scientists of many different disciplines on the one hand, and highly qualified and specialized lawyers on the other hand, for fruitful discussions and debates on an interdisciplinary level, for example, on how the legal framework can cope with the ever faster technological developments, what are the needs of the scientists on a legal level, and so on. As everyone is aware, we are not in July anymore, we are in September, and unfortunately, we are not physically in Trieste, but we nevertheless have this possibility. It was possible to organize 4 webinars this week with 4 different panels on different topics, each composed of scientists and lawyers. And the topic of today is liberty, identity, laws in a world of genes and genomes. We are very happy that we were able to attract no one less than Professor Paolo Gasparini to moderate this panel. Professor Gasparini is a full professor of medical genetics at the University of Trieste. He is head of the medical genetics service and head of the Department for Advanced Diagnostics and Clinical Trials at the IRCCS Mother Child Hospital. He has international experience in the US, the UK, Qatar, and many other places, and he received a lot of prizes and awards, and wrote more than 400 articles in very renowned papers. I will now hand over to Professor Gasparini and wish you a great webinar with fruitful discussions. Professor Gasparini, the floor is yours. Thank you very much.
Thank you very much, Olaf, for this very nice presentation. And hello, everybody, and all the participants. Before starting the webinar, it's important to remind the participants that if they would like to ask some questions, they could use the Q&A section. And it's now the right time to start with the webinar with the first speaker, Professor Anne Cambon-Thompson. They say a good friend of mine, Anne. And she's a French medical doctor specialized in human immunogenetics and health ethics. And she's now Emeritus Research Director at CNRS in Epidemiology and Public Health Unit of INSERM and University of Toulouse. In this webinar, Anne will concentrate on 3 aspects of genomic medicine: the blurred frontier between research and clinical care, the specific dimension of consent in the context of large-scale genome sequencing, and the issues in data sharing and international level as regards personal data protection and family dimension. Please, Anne.
Thank you very much, Paolo, for this nice introduction. And I will concentrate on a number of ethical aspects of genomic medicine, and specifically of medicine today using high throughput sequencing of the genome, and how all these are challenging law and how law is challenging practice. So what I intend to do during around 20 minutes is just to recall this evolving situation with large-scale genomics, and then to consider some of the aspects, some of the issues like blurred frontiers between clinical care and research, the many aspects of consent, informed consent, and the necessity and difficulties for data sharing at international level. And I will do that in the light of the situation in France, where we have a national plan for genomic medicine, and at the same time, a bioethics law that is under revision. So the facts are that high throughput technologies like large scale sequencing are entering medical practice in genetics. It's efficient for diagnostics in context of uncertainty on genes involved, for example, and it's already become technically and economically interesting. But this doesn't go without challenges, because such an exploration of the whole genome or large part of the genome generate unsought for information. So what to do with that? It's complex information where we have different levels of capacity of interpretation of the different aspects of the genome, and they have different clinical significance. The right to know or not to know, which is very classical in genetics for individuals being explored, is much more complex to address in such a context. And anonymization, which is the base, at least in law, for many aspects of personal data, becomes a fiction with whole genome sequencing. So there are a number of issues in this context, and we can ask, can the same type of regulation apply to targeted tests and to genome-wide sequencing? Does sequencing require different kind of consent than other genetic or medical tests? Should whole genome sequencing be done in all cases, including vulnerable adults or children? And how to communicate results when the interpretation is or can be uncertain? One of the issues that has been and is still discussed is incidental findings. So the findings that you are not searching for, but that you find through the genome exploration. And there are some that can unequivocally predict serious disease, but there are also cases where the disease cannot be prevented or improved. The other kind of issues, and I will not have time to go through all of them, is how healthcare providers manage cases in the face of such an evolving situation and a changing knowledge base. How to regulate these sequencing services when they are offered directly on internet to consumers. And then there is the issue of prioritization that is important, and collaborative efforts. And this session is an example of it between all kinds of professionals is necessary. Before I go more into details, I would like to recall the notion of the evidentiary time lag. And what is it? It is that between the moment when a technology is in principle ready to be applied, in clinical care, for example, and the moment when we have data, real data on issues really encountered through its application, there is a lot of a time period with a lot of uncertainty on how to apply optimally the technology. Questions appear like, what are the good practices? What are the actual clinical advantages? What are the best guidelines? And they have to be realistic. And what is the best way to share experience when you would start applying a technology? So deciding on a framework to apply these techniques in practice can be difficult. And this is just illustrated on this little graph. Sometimes it's easier to grasp something where the blue curve represents the evidences gathered, and the red curve is when the appropriate guidelines are introduced. And of course, between the time when the technology is introduced and the moment when you really have the data to know what is best to do, there is this time lag. This is even more illustrated here on the right side of this slide, when there is a lot of discussion, thoughts, and when this man comes to repair the stable door, all animals are already away, running around in the countryside. So this is illustrating the fact that ethicists and regulators are often considered as being either too negative, you know, this will never work, or too late, and that's the story of the stable door. So now I get into some of the issues, and specifically how this technology is blurring several limits that were considered as more or less established. From a specific clinical question, what is the diagnosis for this syndrome, for example, to the whole genome exploration. It's different. Clinical care and research have different frameworks, and there they join. You do a little bit at the same time clinical care and generating new knowledge. We are used to protocol of research in clinical research, but here we are in a context of database-driven or data-driven discovery, which is not a protocol. And then there is the whole issue of health information that is obviously contained in the genome, but there is also a lot of non-health information in a genome. So how do you regulate this the same way or not? And then, of course, body elements, and DNA is a body element, but at the same time, it's mainly information. And legally speaking, I'm talking to a law specialist, and I'm not one, but body elements and personal data are regulated by different pieces of law. And so not knowing exactly when you are in the body element or when you are in the information can generate ambiguities. And of course, clinical utility for health-related elements, but it's not obvious how clinical utility can be established. And then personal utility or curiosity, that is the case for a number of in genetics. So we even have not anymore discrete categories, but a sort of continuum with the evolving capacity of data interpretation that we have, the evolving level of identifiability through the data that we have, and then the right to know or not to know, I already mentioned, may not be applied the same way for all kinds of information. So this is really transforming established concepts and finally giving new information, but at the same time generating a world of what I call documented uncertainty. So now we have had a number of professional societies facing these aspects in genetics. And there have been, that is back in 2013, recommendation from the European Society of Human Genetics. And what I want to concentrate here is the aspect on data generated and what is called these incidental findings. So what the European Society of Human Genetics is doing is being rather conservative and trying to say you really need a clinical reason to prescribe such a test. And they underline what is written on this slide, the importance of databases. Databases in genetics, everybody agrees that it is important. And everybody disagree on for whom it is a responsibility to maintain them. It's not the responsibility of the hospital, taking care of one patient, one after the other. It may be the responsibility of researchers, but not for clinical care. And they may not have all the competence necessary. So who is going to pay? How do you create data banks that at the same time are populated by data coming from research and coming from clinical care, respecting all the rights of the people at the same time? So these are quite important aspects. And specifically in a rare disease, which are not rare in genetics, they are the majority of the genetic diseases. You need to share data. At the same time, you have to respect the rights of the people in terms of personal data protection. We have a number of international texts of reference. It's very important to share internationally, specifically for this rare disease where you have some cases or some dozens of cases in the world. So we have a number of texts, which I just recall here, which are this declaration of UNESCO and a number of reference texts that are not necessarily laws. In the European Union, we refer to the European Union Charter of Fundamental Rights and of course, the General Data Protection Regulation, as well as the regulation on clinical trials for what is relevant for research. We have the Oviedo Convention in the Council of Europe. And in France, we have specific laws, bioethics law, that regulate, among other things, among other domains, the domain of clinical care in genetics. And in the Council of Europe, you also have the additional protocol on human genetics, but in clinical care does not apply to research. So this is in a way not easy to answer in practice. So in France, we have a plan, a national plan since 2016 that is gradually implemented for genomic medicine throughout, and the ambition of throughout the territory. The ambition is that any patient, and this is oriented on clinical care with secondary use in research, anyone where there is a clinical indication, so the indication are already a word in themselves, can benefit from whole genome sequencing. So there are a number of elements linked to the data that are gathered in one place, the distribution on the territory of the different platforms. For the moment, there are two, one in Lyon, one in Paris. And of course, implementing and monitoring all the management tools are important. And there is a working group on ethics, regulatory aspects, and actions towards society. So one of the first things we had to face, I'm one of the co-leaders of this working group, is patient information and consent. So we have a certain legal framework in France, and we had to consult and to see a number of people and stakeholders. Why? Because for the moment, there is not a unified consent form model template for genetics. And as this is a national plan, it had to be one. So there are a number of issues that had to be looked at and seen from the practitioner's point of view, like do the information I deliver encompasses all the issues that the patient needs to understand? Do I have to talk about incidental findings or not? How should I deal with the consent for research? And what about the data and their use in the future? Seen from the point of view of patients, there are also new questions. Like, am I sure that I want to be informed about a genetic condition I am not seeing my doctor for? today. If I have a genetic condition, how will I inform my family? Do I want my genetic data being used for research? And are my genetic data stored in a secured way? So what we addressed was how to ensure that the patients really understand the stakes of whole genome sequencing, which is even more complicated to explain than standard genetic tests. How long which period is going to be covered by this consent in this evolving world. The whole issue of secondary and incidental findings being those information that you see at the same time or incidentally, like the name say it, when you are exploring what you were supposed to and had planned to explore. Secondary findings are those that you actively search for, because the question is, when you have the possibility to look at the whole genome because you generate the data on the whole genome, what would you need to look at? And who is going to decide that? And what kind of information do you need to decide? And so on. And then, of course, genetic data are not only personal, they are also, they concern the family. So the family members, the related members, have certain rights to know if they wish, as well as the patient has the right to have the medical secrecy maintained. So we actually have a bioethics law, which is under revision, and that is taking care of at least giving some legal framework for all these aspects. And what I just want to underline is that until now, the revision is nearly finished now, a strict interpretation of the law was that you could only give results about what the person had consented in relation to the prescription. And of course, incidental findings were not covered, and that was a sort of conscience case for professionals in a number of situations. So the new law that has been voted in the Assembly end of July allows to inform on the possibility of incidental findings at the moment of consent. So people can say yes or no, I want to know, or I don't want to be informed, and give some practical measures how to deal with such findings and how to deal with such findings regarding the family. And this is valid for research and valid for clinical care. So we are gaining with that a lot of coherence in our legal system. But for secondary findings, it is still not something considered. Just like in France, genetic exploration is done or is allowed either for clinical, in clinical care, for clinical reasons, or for research. So all the direct to consumer for ancestry and so on is in France outlawed, but of course anybody can buy it on the internet. So that poses the question of what is really happening when in the world of internet, when you have a law that of course apply in one country, but does not have international application. So I think that now, I don't know why it's not working anymore. Yes, I just come to my conclusion, saying that implementation of such technology is happening now. There are concerns about this implementation and its regulation. We are lacking information, like in the evidentiary time lag, and there are the necessity of studies document in reality all these aspects. Some of the legal or ethical frame need to be reconsidered in the light of the reality of today. And it is true that the change of scale with this large-scale genomic medicine revive classical questions with a new light. And then I want to finish saying that the databases are important and that research and clinics are really linked much more now than they were before. And with that, I thank you very much for your attention.
Thank you very much, Anne, for this very nice and stimulating presentation. I think that the participants will immediately start writing a long list of questions for you. But in the meantime, we can move forward to the next speaker. Is Professor Beatriz San Martin, who heads the intellectual property team at Arnold & Porter in London. She focuses her practice on the life science sector and emerging technologies, and has a significant first-year experience handling cases before the UK courts and the Court of Justice of the European Union, including high-profile European pharma litigation. Her expertise spanned the gamut of IP rights and a wide range of technologies. Prior to pursuing a legal career, she was a scientist with a degree, PhD and postdoc from the University of Cambridge, specializing in genetics, cellular and molecular biology. And it is this that derives their passion for all things genes and genomes. Cambridge is also the place where Watson and Crick identified and described for the first time in a very nice pub the identification of DNA. So Beatrix, please, the floor is for you.
Thank you very much, Paolo, for your kind introduction. Although I'm not quite as esteemed as you, I'm not a professor, but thank you very much. And then I should add also that Watson and Crick benefited from the images of a female scientist whose name now escapes me, who never was awarded.
Rose Franklin.
Yes, who was never awarded.
Right. Without Rose Franklin, we would never be able to find any data on DNA.
So yes, but maybe perhaps we'll pause any controversial issues to discuss for the Q&A, which I should remind everyone that we very much welcome your questions, which we'll try to answer as best as we can after our presentations. When I was invited to present for this event, which I had hoped to be able to be there physically at Trieste, I considered what issues might be of interest to an audience that would be a combination of lawyers and scientists. And so for my presentation, I've picked 3 topics which are of interest to me because I'm an IP specialist, but also because I somehow have become involved with the topics during my career now as a lawyer. So turning to the first of the topics that I would like to discuss, it relates to patent law and the question of whether morality and ethics should play a part in what can be patentable. So first of all, what is the actual legal position? So under the International Agreement on Trade-Related Aspects of Intellectual Property Rights, which is shortened for TRIPS, which was negotiated in 1994 and which all WTO members are signatories. Under this instrument, there was an attempt at global harmonization of intellectual property laws. And this agreement excludes from patentability inventions where the prevention or commercial exploitation is necessary to protect public order or morality, including to protect human life or health. All EU countries include this general exclusion to patentability in their national law. And in addition, in 1998, after a 10-year debate in the EU over how best to encourage biotech innovation in Europe, but at the same time addressing ethical and moral concerns, the EU adopted a directive. For those of you interested, it's Directive 98/44, and its aim was to harmonise the way in which EU member states judge the validity of patents in the biotech field. And this is normally referred to as the Biotech Directive and is there on your slide. Now, this directive wasn't popular by all member states, and indeed several governments challenged it before the European Court of Justice in an attempt to have it annulled, but eventually it came into force in July 2000. And the directive specifically excludes a number of inventions from being patentable for ethical and moral reasons. On the second row of squares in the slide, if you look towards the right, one of the exclusions is the human body, or a simple discovery of one of its elements, for example, a gene. So yeah, the sequence, partial sequence of a gene, but, and this is a big but, if you isolate that element from the human body, or it is produced by means of a technical process, say for example a cDNA clone, then that sequence or partial sequence is patentable. Another exclusion concerns plant and animal variety rights and any essentially biological process for the production of animals or plants, unless, and this is another big but, the technical aspects of it are not confined to a particular plant or animal, but organisms are excluded from this, or technical processes or products of such technical processes are also excluded from this. And the last exclusion or category of exclusions under the Biotech Directive concerns inventions that are contrary to public policy or morality. And the directive includes a non-exhaustive list of those, which are included in the slide for convenience. So processes for cloning human beings, processes for modifying the germline genetic identity of human beings, the use of human embryos for industrial or commercial purposes, and processes for modifying the genetic identity of animals, but only if it's likely to cause suffering to that animal without a substantial benefit to man or animal. And in that slide, I have included three case studies which relate to these exclusions. So the first on the top left hand is the famous Harvard oncomouse. The patent covering that, that mouse was the first one ever granted for an animal. It was quite controversial. The transgenic mouse quickly was seen as an ideal test that could be subjected to toxicological studies on new drugs. Because the mice, you might be able to see there, develop tumours, and candidate drugs can be tested to determine the potential utility of those drugs. Note, however, the tension between the benefit to mankind and the harm caused to animals by this invention, and there was also criticism about DuPont owning the patent and restricting innovation in a very new area. The second photograph on to the right of that, you could see Craig Venter there, and it was a patent application from the Venter Institute in 2006 seeking to protect a synthetic organism made from a minimal gene set. And then this could then be used as a vector for other genes with code for required functions, which in theory could be instructed to produce any number of products, and from drugs to fuels. This application was withdrawn, but it was very contentious at the time, and third parties asserted that they would certainly oppose the application on public policy and morality grounds. And the third example there on the slide is meant to depict the process of fertilization, because the exclusion of the use of human embryos for industrial or commercial purposes led to a series of cases and case law, both from the European Patent Office and from the Court of Justice of the European Union in relation to human embryonic stem cells and what was and wasn't a human embryo. But if we go back to the question originally for this part of the topic, is it right from a policy perspective that patentability should be excluded on public policy and morality grounds? Because even if a patent is granted that doesn't fall foul to one of the exclusions, it's really important to appreciate what patent law can and can't protect. And this is aptly summarised in recital 14 to the Biotech Directive, which essentially says that patent law doesn't authorise patent holders to implement their invention. It merely entitles them to prohibit third parties from exploiting the inventions for industrial and commercial purposes. So patent law can't serve to replace or render superfluous the various national, European, international laws that impose restrictions or prohibitions which monitor research, the use or commercialization of research from the point of view of public health, safety, environmental protection, the preservation of genetic diversity, and compliance with certain ethical standards. And what is, given that, what is the purpose of patent law? And people in my area typically refer to this is a monopoly reward to inventors or the owners of those inventions in return for disclosing the invention to the public, and over time making that invention and technology available to anyone. And this is said to encourage innovation, although I do appreciate that there are dissenting and strong dissenting views on this view. So I'll leave you with the question at the end of this first topic, is that given that patents are a reward for disclosing novel technologies, why should ethics or morality have any say in what is patentable? And with that, I will turn to the second topic. And I've chosen for this a decision of the Court of Justice of the European Union of July 2018, 2 years ago, to highlight the question of whether the EU GMO legislation is fit for purpose given recent advances in genome editing. And the decision is that of case C528/16, Confédération Paysanne. And in that decision, the Court of Justice ruled that organisms created using mutagenesis techniques are GMOs under the GMO directive. That's, for those interested, Directive 2001/18. And they are GMOs in the same way that a transgenic organism, that's an organism that is created by the introduction of DNA from another organism. Both types of organisms are GMOs. Now, there is exclusion of from the requirements of the GMO directive under that directive, but only organisms that are obtained using mutagenesis techniques that, and I quote, have conventionally been used in a number of applications and have a long safety record. We don't know what that necessarily means yet, although I'll give some examples, are excluded from the scope of the GMO directive. Nevertheless, member states can opt for having more restrictive laws nationally, so long as they're not incompatible with EU law. So following the decision, there was an outcry from the agri-tech, food tech industry, as well as from academics and research institutions. And I thought you might be interested in some of the quotes and headlines at the time in the press. A death blow for plant biotech in Europe. a sad day for European plant science. This ruling closes the door to many beneficial genetic modifications, such as breeding of disease-resistant plants that require much less pesticide input. So the CJEU, in its attempt to update the concept of GMOs as used in the GMO directive, effectively sliced up the definition of mutagenesis, because this is one of the ways in which you can be organism can be excluded from the obligations of that directive, but it doesn't offer a coherent explanation as to why site-specific targeted mutations through, for example, the CRISPR-Cas9 system can cause any greater risk to human health and the environment, which is the key objective. The protection of that is the key objective of that directive through the application of the precautionary principle. Why that is shouldn't be included, but traditional mutagenesis techniques such as the use of chemicals and X-rays, which cause random and multiple mutations, are okay. Now, from a scientific rather than a legal perspective, it is rather bizarre that a less precise mutagenesis technique should not require the rigor of an environmental impact and human health assessment as compared to a single nucleotide, which might replicate something that could actually be achieved naturally. Now, exactly a year after that CJEU decision, on the 25th of July 2019, there was an open statement made by 126 research institutions across the European Union, including, from my perspective, because I live in the UK, the John Innes Institute, Oxford and Cambridge University. And this was sent to the European Parliament and the European Commission, requesting them to urgently enable the potential of genome editing for sustainable agriculture and food production. Now, the statement, which is worth reading, highlights that as a result of that decision last year, plants obtained by precision breeding techniques like CRISPR constitute GMOs, as I've explained, in contrast to the much less precise mutation breeding techniques. And as a consequence of this, crops with small alterations using precision breeding, which, as I've mentioned, could arise spontaneously in nature, need to comply with the GMO directive. This is an unreasonable threshold, the statement says, affecting research institutes and small breeder companies because the regulatory hurdles are too complicated and expensive to comply with. And it highlights that the GMO legislation is no longer correctly reflecting the current state of scientific knowledge. The statement goes further to assert that plants that have undergone simple and targeted genome edits by means of precision breeding and don't contain foreign genes are at least as safe as varieties derived from conventional breeding techniques. And in any event, it argues that there are other existing EU regulation for food and crops, for example, the general food safety legislation and environmental legislation that hold market players liable if they introduce crops into the environment that cause damage to biodiversity and protected habitats. And it ends by saying that the CJEU ruling means that precision breeding is becoming the privilege of a select group of large multinational companies, which will have a chilling effect on the investments in R&D in the European breeding sector. And it reflects on the fact that other countries adopt a different regulatory approach, which is much more compatible with the current state of scientific knowledge. And that different approach will likely lead to disruptions of international trade and have consequences for food security in Europe. It then called for revisions on the European legislation to harmonise the legal framework. And since then, there has been a European Council decision requesting the Commission to submit a study on the status of novel genomic techniques, which they hope will lead to a Commission proposal. But the wheels of the EU legislative process are not particularly agile, and the study need only be submitted by April 2021. Remember, the decision was of July 2018, so nearly 3 years down the line, and studies don't necessarily lead to legislative change, so it's unclear the extent to which the new Commission and Parliament will want to revisit the GMO directive. And with that, I'll turn to the last topic, which relates to international governance of biological resources. So in 1992, a number of countries entered into the Convention on Biological Diversity, or CBD for short. This entered into force in December 1993, and it established that genetic resources are under national sovereignty. This is just one component of international governance for genetic resources. There are other instruments and organizations, such as, for example, the 2001 International Treaty for Plant Genetic Resources for Food and Agriculture, the WHO Pandemic Influenza Preparedness Framework, TRIPS, as I mentioned earlier, and the World Intellectual Property Organization, or WIPO for short. Now, the CBD, the Convention on Biological Diversity, has 3 objectives. Firstly, the conservation of biological diversity. Secondly, the sustainable use of that, or of components of the biological diversity. And thirdly, the fair and equitable sharing of benefits arising out of the use of those genetic resources. And a detailed mechanisms for that third objective of fair and equitable sharing of benefits was adopted through the Nagoya Protocol, which is a supplementary agreement to the CBD, in October 2010. And in Europe, in the EU, it entered into force in October 2014 through an EU regulation. That's regulation 511/2014. Now, although there are examples of contracts delivering benefits for countries relating to genetic resources, there are few commercial access and benefit sharing agreements, or ABS agreements for short, that are known to have been concluded under the CBD. And these access and benefit sharing processes that are required under Nagoya appear to have deterred research. And on top of that, since 2016, international negotiations on access and benefit sharing have begun to consider how to address the challenges that arise in research methods taken in respect of or other governments agreed definition of DSI. The term was initially intended to be a placeholder until a consensus could be reached on what was being discussed. It could range from inheritance genetic information such as DNA, RNA, to heard correctly, and checking where it is that people stop listening to me, and maybe I'll recap. Can you all hear me now? Not very well. Okay, well, I'll just recap on my last topic on benefit on digital sequence information, and whether this should form part of the scope of the Convention on Biodiversity as a genetic resource. And I'm hoping that my connection has improved now. you can hear me. So turning to the definition, as I mentioned, it's really difficult to know exactly how to define it because it can range from genetic information to non-genetic information such as proteins, metabolites, and other data. There are arguments to say that non-genetic material should be excluded because, for example, if you're dealing with protein, protein sequence can be accurately derived from a nucleotide sequence, but the same can't be said the other way around. And if traceability of digital sequence information is a concern, which I think it is inevitably a concern if what you're trying to achieve is equitable sharing of benefits of genetic resources, then the argument goes that the narrowest or narrower definition would be most pragmatic. The other problem is that DSI doesn't distinguish between the data and the information. So raw sequence data has to be examined analytically to provide information. For instance, special research tools are used to compare sequences, novel sequence against reference sequences in a database to determine sequence relationship. And there is a huge amount of DSI already publicly available. International Nucleotide Sequence Database Collaboration, or INSDC for short, and I'm sorry for all the acronyms, but this is a huge database and it provides the internationally recognized system of accession numbers for the data submitted. And without it, without an accession number, nucleotide sequence data results cannot be published in scientific journals, and companies also use this as part of patent applications. Now, since 2011, the country of origin tag has become a required metadata for sequence data submitted, and over half the country tagged sequences come from 4 countries: the US, not the UK, the US, China, Canada, and Japan. But metadata can also include information on the origin of the genetic resource. But for example, a botanic garden in a particular country, but only around 6% of sequence entries in the database have such a connection. Some countries have been doing things unilaterally and introducing national measures to regulate DSI. 16 countries have done it so far. A further 18 countries are considering doing this. But in stark contrast, some countries promote restricted access to the use DSI by choosing not to apply measures, and a project is being funded species known to inhabit Britain in the INSDC database. CBD negotiations reflect a divide between user countries resisting further implementation of benefit sharing, in contrast to provider countries which would like further rules and more binding agreements. Most research using genetic resources doesn't yield commercial products. It often relies on many resources, modifications, a number of years, creating difficulties in determining contribution of individual resources and non-monetary benefits. And so users of genetic resources are generally very resistant to the obligations of the CBD and Nagoya into digital sequence information. Discussions are ongoing. It's a very tricky issue. It won't be resolved quickly. And with that, I will end the formal part of the presentation and turn to the Q&A, and apologies for the quality of the sound if you were struggling.
Thank you, Beatriz, for this very nice presentation with a long list of issues raised by you, which could be the base for a very interesting discussion. Let's see if there are questions from the participants. Right now, no. So in the meantime, I can start with one question for you, Beatriz. You mentioned GMOs. Mm-hmm. Don't you think that the perception, the feeling of the lay public on GMOs could be completely different if we are dealing with humans versus animals and plants? And in principle, the two fields should be separated in a way, because otherwise the risk is to stop eventually, in my opinion, of course, the development of GMOs in for human health, because there is a long debate on GMOs in crops or animals.
You've touched on a really interesting point, and you are right that and I should add, I'm talking today in my personal capacity. I am not an expert in policy or public policy, or really I can't say I'm an expert in ethics and morality, but my impression is that the general public are much more in favor of allowing genetic modifications where you have, where it derives a human benefit because of a therapy, as opposed to the use of other uses, say in the agri-tech. And there's a lot of, there's a big synthetic biology or engineering biology community that is trying to develop also solutions in many wide and varied areas, including, for example, waste management, environmental solutions. I mean, I've heard the argument that yes, you could separate them, but in the end, where will that lead innovations for applications other than directly for humans? The alternative could be to use that human and emotive human angle to show why it can be a technique that we shouldn't shut the door on. And I am sensitive to making sure that we have the right measures in place to protect human health and the environment. But at the moment, the way the GMO directive is applied doesn't make total sense from a scientific perspective. I do have sympathy with the Court of Justice at the time. I think that's all they could do with what they had to play with. They were playing with a directive which requires the application of the precautionary principle. So they have to take a very, they can't take a liberal approach to how they interpret that directive. And so the decision in some way was a natural consequence of that. But we are in this difficult position where more crops are becoming resistant to various insects, etc., where authorization for pesticide and insecticides is becoming really problematic in the European Union, and somehow we have to find a solution through that.
One more question for you, and then I will move to Han. You mentioned another very important issue is the environment. Each time a company is developing a new product, like an advanced therapeutic medicinal product, which are mainly based on genes and genomes data information, including the genome editing technology you mentioned. They have to provide a specific dossier on, for example, viral shedding and the impact of the ERA, impact on the environmental risk assessment. But the issue is that patients are going around Europe while the companies usually are located in one site, and they usually treat patients in one site. And it's almost impossible for them to cope with different rural legislations, country by country, on environment. Which could be, in your opinion, a solution? It could be, a solution for Europe. I mean, they would need having one common rule? I don't think so.
I think it's really difficult because, I mean, I've had to live with what's happened here in the United Kingdom as now a dual citizen, but initially just a citizen of Spain. and seeing what the you know, I think it's difficult, but one of the things that Anne said in her presentation, I noted down, is this international dimension. And what I scrolled down, Paolo, was international dimension challenge. We have this huge challenge at in so many different areas on sort of how do we get harmonization and an agreed position that seeks a balanced and fair position for us to navigate. I think it's going to be very difficult, but we can only but strive to get to that. Is the best we can do.
Okay, thank you. And you focused a lot your presentation on consent, and you mentioned many times the relevance of consent, the concept of the future of consent in terms of whole genome sequencing data or massive sequencing. What about the dynamic consent? Do you think could be applied?
Yeah, so the dynamic consent is a consent that can evolve, not just being withdrawn or continued, but can be modified along the line of the time. And this can be done using electronic means. So that's basically for the people who would not be familiar with dynamic consent. So I think this is a possibility. And at the same time, there are some interesting articles on this aspect. Consent is very much turned to the individual. And when
we don't hear you. No? No?
Reconnect your, is your wire connected to the computer?
You can try to reconnect.
Okay. Do you want to ask me another question, Paolo? Or maybe I ask you?
Yeah, in the meantime, I can, we can ask you another question. What do you think about the idea of privacy? Is something in which legislators are working a lot, but the perception of privacy for our generation is completely different from privacy of the young generation. What do you think about this?
So let's just check if Anne is, I won't skirt that, although I would love to skirt that question. Anne, are you able to, do you want to speak and check whether your audio is back on? It's not back on. Maybe check the cable on your, if it's become disconnected. So my view on privacy. So I'm not a privacy expert, but I think it's a really, personally, I try and I'm not as comfortable sharing my personal information and genomic information as the younger generation. So there is this apparent divide. Maybe we're less, it's that balance between trusting what the authorities are going to do, or whoever gets a hand on those with access to that information, what they will do with that information, and the benefits that the younger generation see deriving from the sharing of information through social media, and they draw parallels on genomics. And I think you might be back on because
can you hear me now?
Yep.
Yes.
Yeah.
Okay, good. So I don't know, I just disconnect, reconnect, and now it works. Okay, so back to the dynamic consent. That was your question. I I think that consent is very much down to the individual. And that's also relates to the discussion now on privacy and so on. And when you think about using data for research coming from clinical, for example, you are there for common good, and a sort of societal advantage. So the issue is between providing a service to the person, to the maximum quality you can provide, but at the same time, having those people benefiting from this knowledge, taking care of having others benefiting also from their own exploration. And this is a bit contradictory to a sort of individual vision, which is the consent vision. There is a sort of public health dimension that is very difficult to address on an individual side only. So the consent, and I concentrated on it because it's a legal obligation and sort of guarantee of taking care of what the people think themselves. But at the same time, the collective dimension is not addressed by it, and it's not addressed by the dynamic consent either, which is still turning to the individual. So I think a dynamic consent is one way of allowing a more flexible consent where people can say, okay, for me, I want that, not that, and according to the evolution of the knowledge and of their own perception. But I would like to address a more general aspect, how to inform people and have them sensitized to the collective dimension of what we do through individual genomic exploration.
I have another question for you, Anne.
Yeah.
As a physicians, we have discussed a lot about the role of our national healthcare systems in the prevention of diseases. Mm-hmm. And now with the whole genome sequencing and data available, we could consider most of what you are calling, and we are calling, incidental findings, the extremely important data for prevention. I give you an example. Mm-hmm. A couple of weeks ago was a prenatal diagnosis, and we identified a deletion in BRCA2 gene, the gene for breast cancer, inherited from the father, and without no role in the baby, of course, but with the extremely relevant role for the father, because he could start checking himself and eventually preventing a disease. So which could be the balance between prevention one side on a large scale with a huge information and data, in many cases big data, and on the other side, incidental findings, because I don't want to know nothing apart from what is written in the prescription.
So I think first of all, there are a sort of time dimension, which is not addressed in the consent, which is usually not addressed. You consider that you give results, but it can be that people are ready to hear about their first concern, which is what is happening to them now, but could then be informed of other things later on. Many things are not an urgency in genetics. So I think this time dimension about when to provide the information, both the prior information and then the results, is not enough considered in any of our practices and regulation. And it might be true that people have a first concern and something they have to take care of right now, and later on are more open to other things. So I think that part of the answer to your question would be to consider a process in the time rather than, you know, consent at a time, a result at a time, everything at the same time. And I think this is not worked enough, but for me would be part of the solution, sort of accompanying the own personal evolution of people towards this kind of information, which is not all at the moment and nothing at another moment.
I have a question for Anne, a follow-on. It's related in that, have you worked or given advice in relation to you know, the resistance for people knowing that information, incidental information, because of for insurance purposes now? And I could see that in a place like the US, where you don't have a most of the care pretty much is private, is what information should these insurance companies, private health insurance companies, have access to?
Yeah, I've not directly worked on that, and in France we have quite a strong law that does not allow insurance company to use genetic information. They can use a lot of other information, which is as informative sometimes. It's, but not, they cannot ask for genetic information, and if they happen to know, they cannot use it for their purpose. I think there is also the, how is it called in US? The law in US around non-genetic discrimination. But it might not cover everything, and as you know, and as you said, there are cases where insurance can actually use this kind of information. So I think it's certainly related to that, and that's why the context of the law, where the people are, is important in interpreting their reaction towards this kind of sharing, access, and so on. You said, Paolo, when I could not be heard, but I could hear you, about the privacy and what it means for different generations, I would say. People do not care so much about protecting their identity and their privacy for itself, but they don't want to have a negative effect of other people using their data. So what we are facing is instead of having a sort of easy way to protect people, which is anonymity or protection of privacy, and the consequences positive for the people. And another possibility, which is privacy in itself is not important. What is important is what you do with this kind of information if you have access to it. And it's certainly true that young people who do not care about sharing photographs and a number of things, they absolutely don't want to be discriminated on the basis of their private information. So in terms of law, how does that fit or requires a sort of rethinking the basis of a number of legal provisions? I'm not the good one to answer that, but I'm sure there are people who are more competent than me.
One provocative question for you, Anne, and then I have another question for Beatriz. The question is, you are perfectly right in terms of discrimination, but because we are now thinking that because a part of the population will be sequenced and the part will not be sequenced. But if the whole population is sequenced, since there are bad genes in each one of us, do you still believe that we can discriminate? Because I can start discriminating you, but then immediately you can start discriminating me, and everybody could be discriminated.
I think it is still true because people do not have the same way of discriminating. And I don't know, maybe I could discriminate you, I don't know. But there are a number of people towards whom discrimination could be directed, and that are in a social position or that makes it that it could be even more difficult for them. In a way, they are vulnerable, but they are not strong enough to counter, discriminate somebody else. So I think it's still still important to have this in mind and to have a strong measures to prevent, if possible, and at least then to address strongly if there is discrimination. But there are many other ways of discriminating in the society than just genetic. And I think it's the globality of it which is important. And discrimination in itself has a number of negative effects, maybe some positive sometimes, I don't know. I think discrimination in itself should be not just considered as a specific characteristics of genetics. And that is the difficulty in legal frameworks that singularize genetic information, which is singularized because of the family dimension, for example, but can neglect other ways of discriminating, which might be as severe as genetic.
But you mentioned, Paolo, the bad genes, that might be even a bad, I mean, it's not even discrimination, it's just the misuse or not understanding the data and how to use the data and the complexities of genomics, and the requirement of multiple genes and interactions for any one single, apart from some exceptions. So it's not even discrimination, it's kind of how that information is going to be used and applied that we require protection for.
Yeah, no, I fully agree. It was just provoking.
Yeah, I know.
Yeah, I think we agree.
You, Beatriz. Ownership of the data is again another relevant issue, because in principle we always say the sequencing data, genome sequencing data belong to the patient, but to get those information, national healthcare systems, academic institutions, they have to spend a huge amount of money, people, to investments to get those results, which in principle could be extremely useful for the remaining of the population. So how can we balance the two things, ownership and rights of the individual versus ownership versus the rights and the benefit of each population?
I don't have that is a really, really, really difficult question, which I don't have a structure for. I mean, where to begin, because I think it's finding a way to, rather than ownership of the data, maybe the question is a different question, is protection of that person's data such that it isn't misused, and still being able to use that data in addition to other data in a non sort of identifiable way for that individual, such that it can help with future, help in innovation, developing new therapies, etc. Is trying to find that right balance, rather than focusing on ownership itself. And for companies, they from their perspective, they want to control, own or control one of the two, that data, because if they're going to invest time and money in developing applications relating to the use of that, they want to somehow be able to prevent others from sort of gaining benefit from their investment. So maybe the question to be asked is slightly different. That was very difficult, Paolo.
I agree. And do you think that the current IP framework could still apply in the future for very innovative, in principle, products as those arising from genome editing, or we should think something different?
I think the system is fairly flexible in that you have different rights to protect slightly different things. In the past, for example, written about the possibility that DNA sequences, not those that are DNA, so the code that you can decipher through sequencing, and particularly for synthetic DNA, could that be protected by copyright? And that, I think, is still an open question that has yet to really be that the courts have really yet to kind of fully grapple with. In the UK, which is where I practice, there's no case which really delimits where you may or may not have copyright protection. So so you know, it's not all about patents, and it could also be, there could be molecules with a 3D structure which are not necessarily sort of biological material, not necessarily inserted into the human, which could be protected by, say, design right. And so I look forward to seeing that in the future. I think that it might require some specific, for specific challenges, you might need some tweaks. I don't think you necessarily need new rights itself at this point.
You both mentioned as an extremely relevant point, but also issue, the relevance of data sharing. And but data sharing, which is extremely fundamental if you would like to reach personalized medicine, which is not simply sharing of genomic information, but sharing, as you mentioned, and also and of other information like omics data or a lot of clinical information. How do you see could be the future of data sharing, either from ethical point of view as well as from legal point of view? This is for both, of course.
And you can start.
Okay, so then I start. I think that the necessity of it can be documented easily and argumented with people. So I think that having the agreement of people to share is linked to two things. The first thing is that, well, it's for the good, and there will be no bad consequence for them. So how to guarantee that is part of the solution. The other thing is more on the legal aspect. In principle, you cannot share personal health information, specifically health information, if this is not protected to the same level, I would say, as in Europe, outside Europe. And the kind of agreement that can guarantee that, I think you really need to be competent in the laws of different countries to be sure of that. But I think that there should be some legal provisions for health aspects in order that it is shared for health aspects, but that the rest is really not being used for health or for research in health. And I don't know if, legally speaking, this can be guaranteed across frontiers in the whole world.
You would need an international treaty to cover that. I mean, things can be done. So in terms of kind of how will it be done in the future, I think it will depend on kind of the factors and the priority factors at the relevant time. And I sort of liken it to, and I was going to mention it earlier in one of your other questions, Paolo, that as a result of the COVID pandemic, the European Commission pushed through a regulation very quickly for COVID-19 clinical trials conducted on medicinal products which contain or consisted of GMOs, and it was able to do that very, very quickly indeed. And so, and then there will be circumstances where, for example, if you're talking about genetic resources and the provider companies wishing to protect their own, and there being increased tension there between different countries, where you know, they may place restrictions within their borders. So I think the extent of data sharing will be a combination of the technology that enables that to happen and what tools that are developed to maximize kind of the potential of that data, and then like political and social factors about not just health but food security. The environment is going to be an increasingly problematic issue, which I think will change the landscape of what we consider acceptable or not acceptable.
The last very quick question for you, Anne. France Genomic Medicine 2025 is the year in which your country will start. So you are preparing for that date, or you plan to enroll even in advance?
No, it is already started, and it should be completely developed, implemented in 2025. For example, it's planned to have 12 platforms across the country for making the sequencing and so on. For the moment, we have 2, and they are working. They are in practice, and we will build on their experience for the others to come. So this 2025 is a sort of date for full development of the plan, but the plan has already started.
Thank you very much. I think we are almost at the end of our time for the webinar, because it's 3 p.m. I would like to thank you for both of you, of course, for your very nice presentation and the very stimulating presentation. I think we covered a lot, and probably most likely the time we need to discuss all the several issues related to genes, genomes, liberty, identity will ask for days and days. But I think that this brief webinar focused on some very important topics, and I'm very happy that you did a very nice job in this webinar. So thanks again. I don't know if Olaf would like to say something at the end of this webinar, or if he's already with us. No? Okay. Yeah. So thanks a lot. And unfortunately, I'm going now to the opening ceremony. And I'm very sorry that you were not able to come to Trieste. Today is a very nice sunshine day with a little bit of Bora wind. So the perfect weather conditions to be here. Maybe there will be another occasion in the future to come to Trieste.
Hopefully.
Yeah, I'd love that.
Environment.
Okay, I'm going to follow it virtually.
Yeah, I'm running there.
Yeah, okay, good.
Okay.
Good run.
Thank you, bye.
Thank you very much.
Thank you very much.
Thank you.
Bye-bye.